that these are very vetted. These are really safe forms to use. They're good forms, and also they have notes on use. The Green Book is a form really for estate planning practitioners. So it's a compilation of statutes that are relevant in what we call Title 15. That's where probate and trust lives, is Title 15 in our Colorado laws, our statutes. And then we have a miscellaneous section, which is very long, about all these different Colorado laws that can be helpful and relevant to our area. We have things like the title standards for real estate. We have practitioner forms for real estate deeds and transfers. We have court rules, just a way to kind of put everything that I might need as part of my estate planning practice in Colorado in one book. So I've been editing that now for a number of years, and it is a labor of love. I'm going to stress the labor part. But I do really like it because it also brings me in touch with all the things that have changed that year, right? So the laws that have been passed, the laws that go into effect, the laws that are not in Title 15, but still really relevant to what we do. So it's for me a really, I learn a lot from that process, as much as I feel good about doing that work for what I think of as the sort of the good of our section.
Well, and so many people turn to that book, and so it's certainly not something that someone who's new to practicing law could take on, and somebody really needs an area of expertise to be able to do that. So it's a big deal that you do that.
But I like doing it
Uh,
overall. I really do. And it just helps me keep up to date with what's happening in our section.
and for anybody else who doesn't know about Josie, we've done a whole bunch of Zooms and things like that so that our clients could get to know Josie a little bit better. But I have your slide up, Josie. Maybe tell everybody a little bit more about you.
Yeah. So we have been in Colorado almost 26 years. I went to the University of New Mexico for my undergraduate and then moved to DC, Washington, D.C., after I graduated. I worked there for a while. I was a lobbyist, I was a political fundraiser, I did all kinds of interesting things, and I went to law school there. And we moved here, as I said, in 2000. And I have been a trust and estate lawyer my entire career, starting off at a big firm downtown, moving to more of a boutique firm in Cherry Creek. I had my own firm for the last 11 years, and now Beth and I have a firm together, and I'm back in almost in Cherry Creek, which is a nice place to practice.
And for those of you who don't know me, I am Beth Mitchell. I'm trying to make the slides turn. Beth Mitchell, I've been practicing law for about 25 years, again, in the area of estate planning, probate, and trust administration. I went to Drake University for undergrad and DU for law school. I'm a member of the American Academy of Estate Planning Attorneys, the Trust and Estate section, the Elder Law section, National Academy of Elder Law Attorneys. Basically, this is what I do. This is what Josie does. This is all that our firm does, and we actually really enjoy it, and we really enjoy our clients in particular. So that's why we're so glad that you guys are all here today. And we do have new links for the Mitchell and Fakes Facebook, Instagram, LinkedIn. If you want to follow us there, Cameron put some really good content on there about the firm and different things that are happening in the world of estate planning, which really is actually more exciting than you might might think it is. But there is usually lots of there's interesting stuff that happens in the news regarding estate planning. And ground rules, if you would put your questions into chat, so you've probably noticed we can't see you, you can't see yourself. This is a webinar. So if you put your questions into chat or Q&A, we'll do our best to address them as we go, and then what we don't get, we'll get at the end. So we appreciate that. Um, Josie and I both, as we were looking at this, which is hard to believe because in some ways I still feel like I'm 25, which I suppose is good. But between the two of us, we've been practicing law each 25 years, so over 50 years of combined experience just in estate planning, probate, trust administration. This is all that we do. But as we go through this, one thing I would say is it's hard to give specific legal advice. So if you have a very specific situation, that would be something we'd probably want to take offline because we don't want to lead you astray and give you the wrong answer on something. And the other thing that I would just say is that um, different lawyers do this differently. Even some things Josie and I might do differently. And so, different opinions I think are important to have. And so some things that even as we talk about today, I might say something and Josie might say, actually, I might do it differently. And that's just, the same way that doctors do have different opinions on things. We're here to serve you and answer questions today and talk about how you can actually make this your estate plan work for your family. And that's why this is a very kind of hands-on thing. It's not as much of legal advice today, but just more hands-on and really how to talk to your family about your estate planning. You know, I in the world of estate planning, people never used to talk about this because, it meant that we were going to die. And so what we have found over the years is that talking about this in your family is actually really helpful. It makes this work a lot more smoothly. It makes people understand what their jobs might be in a time of crisis, and it answers questions about how they need to start with the process if something happens. So, Josie, one of the first things that I always talk to clients about is where are your documents? What do you talk to clients about where they keep their documents and how to connect the dots for their family?
Well, because one of the things I was thinking about this morning is I was looking at the title of our webinar, How Do You Talk? How do you talk? Like, how do we do this? And words like openly, honestly, but in a way that also makes sure that you feel comfortable with that level of disclosure, right? This is hard. A lot of my clients I call close to the vest. They hold those cards real close to the vest. They don't want people to know things. And we say, but how do you balance the tension between wanting to keep your privacy and also wanting to be sure that people can use these documents and help you when that's necessary? And I think that's a real challenge for many. And I'm going to say sometimes my older clients who feel generationally, just like Beth said, right? We don't talk about these things. We don't bring them up. I don't want to depress my kids. I don't want to make this hard. I don't want them to know what I have. They shouldn't know how much money I have, right? There's a lot of like emotional stuff that can go with this process. So as I was thinking about the word hard this morning and talk, like how do we talk? I do suggest openly and honestly, but tempered with that, what do I feel comfortable with? So, where are your documents is a really good question. And I will tell you guys in my own life, my grandmother died last summer. She was 96. She was ready. But no one seemed to think that we should find that will. It's not like I'm a trust and estate lawyer or anything. So after she passes, which is again feels shocking to my family that she does, the scramble for where is the will has never been solved. No one can find her will. And we think, well, it's easy. She probably gave it to her two kids, my mom and my uncle, right? But where are your documents is something that in my family is not a talked about subject. So when the time came to need those documents, we now are stuck with an intestate probate in New York, and her wishes that were other gifts that we are pretty sure were in that will are never going to be made. So on this list, we have this, where are your documents, things that help your family. I tell people at a minimum, and tell me, Beth, if you're the same way, which is like, at least tell them where they are in the file drawer in the basement in a file marked estate planning, or in the safe and here's the combination, or in some basic direction so they have a map to follow as they try to find where your things are. Is that kind of where you start, Beth?
Exactly. And I find that, we all do things that in our head make sense, but may not make sense to other people. So the fact that you might keep it under your bed or hidden in the secret hidey hole underneath your floorboards or something like that makes perfect sense to you, and nobody else is going to find it there. And if you can have the best estate plan in the whole world, but if nobody can find it, it will not do any good. So, and along those same lines, and again, I appreciate we want to keep things private, but the combination to the safe, um, somebody has to know. Somebody has to be able to get in there. They can
Beth and
drill
I
the
have hired a
lock.
lot of people to drill safes over the years, by
Yeah.
the way. Safe deposit boxes, safes in your home, This is we have to get in, and to make it so that no one can do so just means that we have to ruin that object to get inside.
And it takes time. Some of this is time sensitive. If somebody is sick, your medical power of attorney being in the safe is going to make it really hard for your family. And so I'm not saying you have to sit down and tell everybody, I have this account and that account and this account, and this is how much you're going to inherit. And by the way, you're disinherited, or anything like that. But just where is everything? Where's the paperwork? And that's the most basic thing that I would say everybody should start with. And
And I
then
like on
in
this
there,
list how we also have, a list of your advisors. Who do you work with, if anyone? Do you have a financial planner? Do you have a life insurance agent? Where's your homeowner's insurance, your car? This is helpful information to all put together in one place. And if you've worked with our firm, then you know that when you got your binder, there's lots of pages in there for you to place this kind of information. In fact, the last tab even says, do you want to put things like birth certificates, marriage certificates, divorce papers, things that you think people might need in the future for our military veterans, making sure that we have your paperwork so we can get you buried at Fort Logan instead of trying to fight and scramble and search for the documentation that we need to do so. People will sometimes say to me, how will my family know I have life insurance? I said, well, you will tell them, right? There isn't like a magic database in the sky. So putting all this information together, having, we also have on this list usernames and passwords. I have to tell you, and Beth can tell you some stories too. This is a real problem for us. In the olden days, when we first started practicing, the way to find out about someone's assets were just wait for the mail, right? The mail will come. Well, now we have clients that get no mail about their assets. So, how do we get on your computer? I'm right now trying to help a client get onto his wife's iPhone so he can get the photos. Well, that requires a court order. These are difficult issues to deal with. If he had known her password, if he had been able to get into her computer, right? And I know we're all worried about privacy and safety. So understand that we're not trying to encourage you to share this information with the universe, but finding that person in your life, if you have one, or a professional company where you can share this information so they'll have it when they need it, is going to save people a lot of grief in looking for what they need to find to help your estate or to help you.
I have a friend whose father passed away recently, and she called and she said, Beth, they won't let me into the morgue to get his fingerprint to open up his phone. And I said, no, they won't. She said, well, what do I do? I said, dig around the house and see what else you can find in terms of paperwork. I mean, the privacy stuff is designed to protect us when we're alive, but when somebody passes away or there's an accident, there's an incident, it's a real hindrance. And so the more information that you leave, the better. And even a more complete list of assets. You might think if you say, okay, well, all the documents are in that file drawer, that it will make sense. But when they find that life insurance policy from 1975 and they aren't sure if it's still in effect or not, and the CD that, matured in 2012, just having a list of assets all in one place makes it so much easier. And that's part of what this is. You do your planning to make it easier in the event of death or a crisis. And so you want to leave that information so that they don't miss something. Because if they miss it, if they don't know that there's an account at Belco and they never go there, after a couple of years of inactivity, that money is going to go to the state of Colorado. That's your hard-earned money. We don't want that. You don't want that. So a list of assets is probably hands down the most important thing that I can tell people to do. And it's the easiest thing. You don't even have to have us do it. It's free and easy, right?
And you'll see in your
Um,
binder, we also have a place for you to do that. Because those of you who've worked with us, we have a questionnaire, but we're not asking for names of your banks. We're not asking for account numbers, right? We're asking for you to tell us how much you have in your 401k. So we can talk about that as part of the plan. But I don't know that your 401k is at Vanguard and this is the account number. right? Or that your IRA is with Schwab and this is the account number. So I always say, don't make it a scavenger hunt, right? At a time when people are grieving or dealing with hard things, and to make this even harder isn't helpful to them. One of the things we have on here is personal property memorandum. And you guys might recall that that's the separate written list, that separate written memo that you can fill out to give tangible personal property to people, right? So your jewelry, your furniture, your blender, that's people often say to me, where do I put that? And I say, well, put it right with your estate planning documents, right? Put everything as easy as you can together for people so that they're not engaging in that scavenger hunt to figure out how to effectuate your wishes. Make it as easy as you can. And some people talk about a doomsday folder. My mother-in-law, who did die of an aneurysm very unexpectedly, had basically all the stuff to know when I die folder. She was the most organized lady I knew. She had birthday cards for the next year, all filled out and in a file by month. I mean, this lady was amazing that way. But it was her husband who was in shock, in grief, in disbelief that she had died, was able to open this folder, and everything was there. Everything from the electric bill to the mortgage payment to the investments, right, to their estate planning documents. Everything was in this folder for him. And the relief for him, because as you can hear, he wasn't that guy in the marriage, right? She was that gal. The relief from him to have all of that spelled out for him was immense. And I could see that. And I think this is, I mean, and we're also, by the way, Beth, you can disagree with me, but I do practice what I preach, right? I have an estate planning questionnaire filled out with all of my detailed information, because if my husband and I are both not here, we need to have people step in and know all of this. This is not just something we tell you guys to do. We do it ourselves because we see how hard it is when it isn't done. And maybe some of you have experienced that too. If you've had that experience, put it in the chat, share it with the group if you feel comfortable, right? Kind of where that led you or how that was difficult for your family. Because having all of this together is really helpful. And Beth, maybe you could talk about DocuBank a little bit, since I haven't worked with them so much yet.
Yeah, and I apologize. It said discussed earlier. I think we're actually talking about it. I might have a slide for it later, but DocuBank is a service that we get a discount on for our clients. And what they do is they keep electronic copies of your medical power of attorney, your living will, your HIPAA release. It's for the medical stuff. And then you actually put it in your wallet, and they recommend that you actually put it in front of your driver's license. And there's a little sticker also that you put on your health insurance. So that if something happens to you, right, and you show up at the hospital, first you know that they're going to go through your wallet to figure out who you are and if you have health insurance, but then they can find the DocuBank card the hospital calls DocuBank. DocuBank sends your documents to whatever hospital you're at 24/7, and they also have your family's emergency contact information, which just connects the dots. Again, that's what a lot of this is, just connecting the dots. You're just trying to make it easier. You can make this hard or you can make it easy, right? And a little bit of work in this area goes a long way to making it easier for people. Um, and this is what we were just talking about, the list of your assets, the location list form that we've given you, usernames and passwords. The other thing I always tell clients is it doesn't matter what your system is. And you don't have to reinvent the wheel. If you have a master password program or a spreadsheet or a notebook or a Knockbox, or you've bought some other kind of folder or whatever it is, it doesn't matter. Just tell somebody, what it is. And
Funny, we have
I,
hidden assets on here. I think of this being the asset where someone says in a meeting, "Oh yeah, I do have this partnership. I have a third of this partnership that owns this building. I've had it forever," and they say it offhand like it's not important. Well, who knows about that? Now the tax returns might show a K1, right, from that partnership. Maybe it doesn't. So those are the kinds of things that you'll want to say, oh yeah, maybe my family doesn't know that I did this. Maybe no one is aware that they have this piece. That maybe that it's not an easy to discover asset. If the whole point is to move your assets and your wealth to your people once you've passed, making sure they know what that wealth is really step one.
And I will say, I don't see as much of this as I used to, but if you do have gold bars hidden in your house or a lot of cash, that is important to tell people. I did have a client once whose parents they would put cash in the pillows. They stuffed pillows with cash. Um, and the gold bars were in shoe boxes in the closet. So if you do have those kinds of things, it is important to tell
So
somebody where they are.
I'm going to pick on my grandma again. I'm sorry, we called her Mama. Sorry, Mama. But there was $40,000 in U.S. savings bonds in her underwear drawer. And when I pulled them out, my uncle said, "Oh, I wondered where those were." And I no offense to my lovely grandmother, but and maybe she figured eventually someone would clean out her drawers and they would find those there. So that seemed like a safe place. And again, she was an older lady, and maybe she just decided this was a good spot, and that made sense to her. But it's only because I was there cleaning out her dresser drawer that we found quite a bit of, I mean, over $40,000 in savings bonds. So yeah, hidden assets also quite literally doesn't really help people unless they know where to find them. So luckily we found them sooner rather than later, but they could still be there right now, and that wouldn't be surprising to me.
It always makes me laugh. At some point, we should just do a like funny stories thing because I've seen some weird stuff, especially with this kind of thing. Whether it was somebody who rolled up $100 bills and she had a brass bed and you could screw off the top of the wall. She would put them in the bed, and when she died, the family sold the bed and then one of the family members said, "Oh, you didn't sell the bed, did you?" And they're like, "Yeah, we sold it at the garage sale." You know. So we've seen some interesting things. So maybe sometime we'll do a class with just some of the different things that
The
we've
hidden
seen because
things.
it's funny.
Tessa
Yeah.
shared a comment that her parents used to take her on a tour of their home and point out things like their documents and their keys, and how helpful that was later on. It can seem grim, but I think part of that is we in America have a culture of youth and a culture of aging is a failing, and death always seems shocking. And other cultures don't have that, but we do. So I think it always feels like, oh, what you're talking about, like that'll never happen. Well, I'm here to tell everybody, if you didn't know, just in case, this is the one tidbit you'll take away today: we will all die. So treating that as a fact as opposed to a fear, or again, like somehow it's this failing that people get sick and die, or get older and die, or just die at all, um, I think leads us to feel isolated and not having that discussion. So I'm glad, Tessa, that although it felt grim, you still went through it with your people, right? And then you did the same thing with your oldest child, you say in your message, which then again, it's that culture of openness and that culture of really accepting that this is how the world works. We will all die, and that's okay. Maybe it's not okay, but it is the reality we live with. And so treating it like an inevitable, right, is going to help your family when the inevitable happens.
And I think because it can be so difficult to talk about, that's why you do have to keep reminding them, right? Like Tessa, I'm keep saying like she kept on going over the tour of her home. Sometimes once is not enough because people hear for the first time they go, I don't want to talk about that.
Right.
Okay, I'll just remind you again next time. So that repetition um, is helpful.
And
It doesn't have to be digging it in either. It's not like, it doesn't have to be gloom and doom. It's just, hey,
right.
this is where the stuff is.
And I like that we have on here digital copies. After you execute your estate plan, we usually send them to copies to you as PDFs. so that you have them on your computer. You can email them to your family members, or maybe just the ones you feel comfortable with, right? My daughter's my medical power of attorney, so I send it to her. My son is my financial power of attorney. Maybe I send that one to him. You don't have to, you can choose and use your own discretion as to what feels comfortable. But so many of my clients say, I'm sharing copies with my financial advisor. So if the kids call that person first, they have them. I'm sharing them with my kids. They can put them in a folder on their computer that says, doomsday for mom and dad, or whatever is on there. Whomever you have listed, who are the people you're going to rely on upon your disability and upon your death, let them know they are these people. And here's the documents you're going to use when the time comes to use them. So those digital copies, we do, I think in the olden days, we would give people, a floppy disk with their documents, or even a thumb drive,
We were
which a lot
cutting
of
edge with the
computers don't
floppy
have
disk,
thumb
I'll just
drives
say.
now. So we just do it as here's your PDFs electronically. Hopefully that's going to stay around for some time. But that way you can share them easily, and they are also uploadable to, like, for example, your doctor's office. Most of us have a doctor's office that now has some type of website that has a portal, which I find very irritating at times. But one of the helpful things is you can upload your medical power of attorney, your living will, your HIPAA authorization, so that your doctor's office has those too. So that we're trying to, again, just get information into the right hands so that when we need it, no one is scrambling for it.
The other thing that I would just add with those digital copies is that even though you have it digitally, in the world of estate planning, we're old school. So do not throw away your originals. They will need those. The original will, a lot of times the original power of attorney. The medical stuff, typically people will take a copy. And so tell your family, you're gonna have the medical stuff. Hold on to this. It's your job to show up at the hospital with this. Because even though there's the portal where you can upload information and documents, I'm not as trusting that they're going to be able to put their hands on it in an emergency. But if my family knows, right, my loved ones know you have to show up with this, then I feel like it'll get to the right place. Um, so I think the digital copies are helpful, but again, don't get rid of those originals. So when people think about estate planning, most of the time they think about the what happens after death part, but I think that what happens if you become ill or injured part is just as important, if not more important.
It's harder, at least,
And
right? That's at least it's
yeah,
a harder thing to become disabled than it is to die, in
yeah,
terms of
yeah.
legally.
I think so too. I mean, well, and it's something that I assume, more aware of. So the durable general power of attorney is the document where you're appointing someone to make your day-to-day financial decisions if you can't do it for yourself. And this is one where a lot of times the banks and financial institutions will still want the originals. More and more are taking copies, but they will still want the originals. So again, this is why it's so important to tell the family, tell your loved ones, tell your agents where these documents are, even if you give them the digital copies. Now,
I
powers of
understand.
attorney are effective different ways. Josie, do you want to touch on like how those documents come into
Sure.
play?
So the one document we're talking about here is the durable general power of attorney. So this is the one that's not healthcare, right? We have the healthcare power of attorney, the medical power of attorney, which is its own sphere, and then this is everything else. I say this is the asset, the pay your bills, the file your taxes, sue the person that ran you over, that put you in the hospital in the first place. It's everything else except the medical piece. And for many of our clients, when they're not naming their spouse, they say that this power is going to be effective upon their incapacity. So there's two flavors of powers of attorney. You can have it be immediately effective, and clients will sometimes say, well, if I do that, my son could take this document and steal from me. And I say, well, then you probably shouldn't name your son if that's your concern, right? The first real issue is who do you name, but that's another story. So when is it going to be effective? If you say upon incapacity, That's fine. No one can use it until they can prove that you are disabled. How do you prove it? That HIPAA authorization where you've said my agents have the authority to access my medical records, right? Because now I need to get proof. Your doctor must feel comfortable issuing a letter to me saying that you had a stroke and you were unable to manage your own affairs, right? You're in a hospital bed, you can't speak, you can't move, you maybe not be conscious. And so I need to have the doctor certify that to me so I can go to your investment person and say, here's the power of attorney, here's the proof this person's incapacitated. Now help me create some liquidity because we have medical bills to pay. Right. So there's sort of this line of how do we get things done? We don't just show up and say, this is me, right? If it's only effective upon incapacity, it's going to be a situation where you have to prove it. And this just came up for me. Lovely older gentleman, his wife died, and his sister-in-law is trying to help him because he is physically disabled. He cannot leave the home at this time, but mentally sharp as a tack. Well, his power of attorney says that for his wife, it was currently effective, like we do for most of us that are married. And then for anyone else, it was only upon incapacity. So sister-in-law reaches out to my lovely client's physician and says, I need a letter that says he's disabled because I have to go to the bank and deal with these accounts. And the doctor said, I can't issue that letter. He's mentally just fine. He's just physically incapacitated. So that's what we're talking about here. Incapacity doesn't have to do with being in a wheelchair or a walker, being able to move. It has to do with mental. So he says to me, I need to sign a new power of attorney that is currently effective. It's effective immediately. So my sister-in-law can go do these things for me. So that's what we did. And we had a traveling notary go to their home and so but that's one of so you can see just in that situation that there's just hurdles to using these documents. And even though we have good reason to do what we do in the drafting, sometimes in the real world it becomes an impediment. And that's not a story to say you should have a currently effective power of attorney, but just understanding some of the hurdles that can be there to use this document and what kind of jobs the agent's going to need to do for you.
And so this would be a good thing to tell your family. If you have a power of attorney that only becomes effective if you're incapacitated, boy, wouldn't it be helpful if the person that you named was aware of that and that they knew that they were going to have to go get a letter from a doctor first? Because the other reality in a post-COVID world is that getting a letter from a doctor is going to take some time. I can't get in to see my doctor for at least a month. And I know people who can't get in to see a specialist even longer. So, and then you have to wait for the letter to be written. So if the family knows, if the people that you're naming know that they're going to have to get that letter, that would be helpful. The other thing I think it's really important to talk to your family about with this, if you can, and that I will say with all of these things, only if you feel comfortable. But if you can, I think it's very helpful to tell your loved ones who's in charge of this. Who did you name? It doesn't have to be something where you're trying to hurt somebody's feelings. That's not what this is. But if you have 3 children and they all think they're going to be in charge, then it's a shock to them. And so if you can say to them ahead of time, listen, this one who's going to pay the bills, it's going to be Susie. It makes it easier to set everyone's expectations, reduces the likelihood that there will be arguments in the future. And as I always tell people, this is not the person who inherits anymore. This is just the person who has to do all the work. And so, hopefully the other kids or the other family members won't be as upset. I don't know, Josie, have you had experience with people talking to their families about who they're going to name?
Absolutely. And I've had a lot of pushback over the years, although less, I've been, again, doing this 25 years. And earlier in my career, I felt like clients seemed less inclined. They seem less inclined to make that kind of disclosure. But I think it's important to talk to those people, whether they are children or friends or extended family, because some people don't want to do it. Right. And clients will report back. I asked my best friend and she said, no way. She said, your kids are just terrible. I'm not dealing with them on that level. I don't want to handle that. I said, well, good to know now. Because when you name someone in a document, that doesn't mean they have to do it. This is part of why we ask you to come up with an agent, a successor agent, even a second successor agent, because maybe my husband incapacitated in the same accident with me. I've named my sister, but she's in the middle of dealing with breast cancer and says, I do not have the spoons to manage this for you. And so now it's going to go down, right? So no one has to do any of the work that we name them to do in any of our documents. So prepping them ahead of time and then talking to them about what's important. I've had clients say to me, I never want to leave my home, even if that requires 24 in-home person care. I said, well, that's going to be about $350,000 a year. 24-hour care in your home. And they say, I don't care. I have plenty of money for that. Then put it in a document that that's what you want, right? If you're looking for really specific things like that, don't just trust that people will know what you want to do. We want to put it in there and then have that conversation with your loved one or the person that you name. Have that conversation about, I understand it's going to deplete all my assets, but this is what I want. Right, so like having that discussion ahead of time, because when this is being used, you're not going to be able to have a discussion. You can't give information at that point. You can't make directions, and the people you name will feel so much more secure in the choices they're making if they feel like they're effectuating your choices. Right. And I don't mean you have to get into the nitty gritty of this, that, and the other, but I think, yeah, 350. And I'll tell you why I know this. 13 years ago, it was $260,000 for my client to do it. And I can't imagine in the last 13 years, the price for that hasn't gone up at least another $100,000, not even quite 100,000. So I saw it with my own eyes, and yes, it's because 24/7 care, do the math. It's crazy. But this is what the woman wanted. Her agent knew that. And so that's what her agent did. Again, talking to your people about what is important to you. What are your values as it comes to your care, your money, your finances? That is the only way people are going to do what you want, is if they know what you want. Otherwise, they have to substitute their judgment for yours. So having uncomfortable conversations it's gonna save them the stress. And they're already stressed. They're already doing a lot, but they're gonna say, I know that I'm doing what my uncle wanted. I know what I'm doing what my cousin wanted or my son wanted, right? That's a really helpful discussion to help the people that you put in charge.
Yeah, absolutely. And we see this just every day when there's been an incident. And so Josie touched on the HIPAA release earlier. All of you, so HIPAA passed in 2004. All of you have done estate planning with us, have a HIPAA release, and it is critical. And that HIPAA release that you signed with your doctor's office is not going to cut it, because your loved ones, your agents need a HIPAA release so that they can talk to whatever medical personnel they need to. This is all about the free flow of information, and they need it to prove that you're incapacitated to make the general power of attorney work, and they also need it to be able to help with the medical decisions. The medical power of attorney, this is who makes your day-to-day medical decisions if you cannot do it for yourself. And my experience with this has been that typically medical personnel will take a copy. They just want to know who's in charge and what to
They're
do. They don't.
they just want someone to be in charge. They really
Yeah,
don't care. This is a very easy document to get accepted, unlike the financial. They are thrilled someone has shown up, right? Because
yeah,
they're looking for guidance. They're looking for someone to connect with who's going to help them do what they need to do for you. And that's also nice because things happen very quickly. So I've had clients ask me, what if I have a car accident and I need to have surgery right away? Are they going to wait for my medical agent? And I said, no, if you're in a trauma situation where you will die, they're going to take you into surgery. But it's the after part, right? Do we do this? Do we do that? Is there rehab? Do we go home? Should we have, right? All of that decision. So understand that they're going to save your life without a medical power of attorney. But it's all of the after part that we're really talking about. And if you don't have one, then someone in your life will have to petition the court to become your guardian. So also talking to your loved ones, This is just as critical, probably even more so than the financial power of attorney. Saying to people what I want and what I don't want. And this is not about a living will. We'll talk about that. This isn't like the end of life. This is sort of what measures do you want me to go to? How if I'm incapacitated with dementia and I have cancer, should my children treat my cancer? Sometimes it's really talking about what your values are as to the sanctity of your life, the importance of care for you, the level of care. My grandmother at 92 had a very, very tiny breast cancer and she wanted it treated. Well, she had the capacity to ask for that, so it was treated. We knew that was her value, which was she wanted to live to be 240. So we knew that she was going to do whatever she had to do for that. But if we had to substitute her judgment for her, we want to know what is her value that way. And there is a questionnaire that I've worked with for years that was a collaboration between physicians and attorneys, where physicians said, we'd love to have some more information from the person who executed the document about what kind of level of treatment they want in different scenarios so we can better advise the agent. And clients would say, this is too broad. I'm not really sure what to say. And I said, of course not. But try your best to give a little more guidance. It will make it easier for your loved ones and the people that you've named to make those choices for you.
And I think it's important when you do the medical power of attorney, one of the reasons that you're doing it is that you are picking the person that you think will help fulfill your wishes. And this has to do as much with the actual choice of medical treatment as it does with how you're treated in those scenarios. You, most people would want to pick someone who isn't going to bulldoze over them, who's going to still involve them, allow respect and autonomy and involvement, even when someone might be needing help with medical care. Because some of this is after an accident, but the reality is, I think a lot of it is more to do with aging. And so as this person goes to the doctor with you or the hospital with you, it should be the person that you choose whose values would align with yours, who's going to respect your values, who's going to involve you, so that even though you have that backup there to help, that you're still a part of it when you can be. And I think that's just as important. And again, also telling your family, hey, listen, when there's a medical crisis, it's going to be Bobby this time who's on deck. He's going to be the one that will do that so that there isn't fighting at a time of crisis in the hospital. We want everybody to be clear about who's actually in charge. One other thing I will point out is that my clients are often worried that their family or loved ones, that someone will feel left out, particularly when it's the children. If I name Bobby to do it, then Susie's going to feel left out. And so that's something that you talking to your family about really helps, because then you can explain this is not about leaving you out. It's about the fact that, he's retired and you live in California, or whatever reason it is for the decision, so that people can understand, and that smooths it over at the time that they actually have to act.
Less surprises, the better. The less
Yeah.
shock and disappointment, the better. And so, but again, clients sometimes say, I'm going to open a can of worms if I do that. And I think, well, then you're going to be in the hospital and that can of worms will be opened. That seems like a terrible time to have your children fighting. And so saying to that person who you think will expect to be named that they're not named, at least that's out there. At least that's known. And so they're not fighting, Sally's not fighting with Bobby at the time something happens to you about her hurt and her disappointment. And instead they're focused on you.
And that's, I think, no more true than in the living will. And luckily, the living will is not the document that we see being used the most. The medical power of attorney is what you see being used the most, but the living will is there for that situation where two doctors have said that you have a condition that is either terminal or you're in a persistent vegetative state and you're unable to communicate and you're on the ventilator, on life support, you're not breathing on your own. And this is your opportunity to make sure that everyone knows when you want life support and artificial nutrition and hydration to be removed. That way, they don't have to decide. You are the one that's deciding. And there's nothing that I think is more important to be clear about than this, because this one is hard. It's really hard if people have to use this, and it involves a lot. There's a lot of family dynamics. There's a lot of religion, guilt. There's, boy, that it brings up everything. If I remove the machines, am I letting my mom die? Am I killing her? Is it my responsibility? We don't want anybody to feel like that. And that's why we do this document, so that everybody's clear as to what you want. It's not on them, on their shoulders. They're just fulfilling your wishes. And if you talk to them ahead of time about what you want, they're going to feel like they're fulfilling your wishes. And they're not going to see the document for the first time and think, this can't be right. There's no way that my dad would want this, right?
Right.
We want everybody to know ahead of time. Not that this is ever going to be easy, but that makes it as easy as it can be. Josie, I know you've had even personal experience with this.
I do. And I have to tell you, like, it's such a terrible time. People are out of their minds, right? No one's thinking straight. This is a really difficult place to be. And to have, how many times, Beth, has a client said to you, my mom went through this, she was on a ventilator, but she had a living will. So I effectuated her wishes, right? I did what she wanted me to do, which lets your loved ones off the hook. Even when they are following your wishes, half the times they still feel very guilty, like they killed mom or they were responsible for dad's death. This is really painful. And at the bottom of this list, we say some medical powers of attorney let the agent override. So my situation was this, and if you're my client, you've heard this story, which is my mother-in-law, my husband's mom, had an aneurysm in 2015. She was playing Scrabble with her husband. She gets up to wash her hand and she just collapses, and they get her to UC San Francisco. They hook her all up. They look in her brain. It is a bowl of oatmeal. She had two bursts in her brain stem. And if you know anything about brains, which I barely do, you can't live without a brain stem. So they kept her alive, barely, on life support. She was both terminal and in a persistent vegetative state. So we kind of hit all the buttons on that one. And her living will said 7 days. Well, it was clear after 7 minutes that she wasn't going to survive this, but she had marked that her husband, as her agent, could override that number. And he chose to shorten the number of days. So my husband flew to San Francisco. He got to be with his mom. And then they decided to turn off life support. And when I say people were out of their minds, no one thinks clearly. No one thinks clearly at this time. And it's, again, we talk about these documents in the abstract, right? In an office, here on Zoom. We're not in a hospital where this is all happening in front of us. My grandmother was on a ventilator this summer. And for my uncle to decide to take her off was very, very difficult, even though she had a document that no one could find, that said that she didn't want to live that way. So in the moment when you use these, it's very challenging to expect our people to be rational, thoughtful, calm people, because that's not what's happening. So having a living will where you've taken that burden off of your agents and you've said, this is the situation, and when I'm in it, this is what you're going to do, just takes all that pressure and pain, I think, off of people, and they can simply be grieving. They can simply feel like they're doing what you wanted them to do. So having that discussion, when we talk about, I mean, the whole title, How to Talk to Your Family, I think it's important to say during the hardest times, we can't talk. The opportunity for that conversation is over. So having it now, even though it can feel uncomfortable or sad, is really going to be more helpful. Now, how many of us will use a living will? Not many, right? You have to hit all those buttons for that document to come into play. We see it a lot on TV and in the movies, but it's just not that often. But God forbid that is your situation. Having had that conversation will make the process, although still very painful for people, it's still going to make it easier.
Yeah. Yeah, and it's All of this is difficult. And I just always say this is the whole point of estate planning. You're trying to make it as easy as possible in a really tough situation. We've already talked about DocuBank. And I do think that DocuBank is a great service. Some things to keep in mind that your loved ones are human, and as much as you give them copies of your documents, they may not know where they are. I never lose anything, but they may not know where your documents are at that time. And so DocuBank can be a great service for that. Um, Keeping information in your wallet about who your emergency contacts can be is a great option too, because I know that your phone, just like mine, all of them have they're secured. So the hospital can't get onto this to see who your emergency contact is. So you kind of have to go a little old school with some of this, and but DocuBank is a great solution. And if you have questions about that, you can always contact us. But when we sign documents, everybody got a brochure for DocuBank, and you can go and look at that as well, because it is just a nice way to connect the dots. Oh boy, the Declaration of Last Remains. And Josie, this is definitely one as you're talking about, this is when people can't talk. And I have clients all the time who will say to me, I don't know. I don't know if my mom wanted burial or cremation. We didn't talk about it because people
Right.
don't like to talk about this. I remember, so I grew up in a small town in South Dakota, and my parents were planners. I wonder where I get it from. They were planners, and they used to walk at the cemetery, which I know sounds strange, but it was a mile loop and it was beautiful and it was close to our house. And so one summer I was at home and I went for a walk with them. And as we were walking by, my mom said, "Oh, look, they have our stone up." And I went, "Oh God." It had their dates of birth and then the line. And I was like, "Oh my." And I do this for a living, right? But it was a gift, right? My dad passed away about a year and almost 2 years ago now. It was a gift. We knew exactly what needed to happen. It was already there, it was already taken care of. And so, how far somebody goes with the planning of this is completely up to them. But at a minimum, your declaration of last remains, which is binding on your family, will say burial, cremation, or some of our fun new options in Colorado: composting, water cremation, green burial. Um, this is important to tell your family what you want.
Yeah, and before, and Beth can attest to this, before we had a last remains form, one of the most common questions I'd get from a deceased client's family is, what did my mom want to do with her death? Like, I don't know. It wasn't something we had done sort of routinely in our estate plan. And now we have a last remains form because the fighting over remains, which we won't get into, but is colorful and horrible, as you can probably imagine from even that brief description. So having that direction, I tell people just at a minimum, tell cremation or burial. Right? Just give them some basic guidance. And the older I've gotten, the more fan I am of pre-need planning because I mean, and I just saw it this summer. Again, my grandmother passes. My uncle isn't sure what to do. He goes to the same funeral home that we used for my grandfather 20 years ago. He buys the Cadillac of caskets. He gets the whole enchilada for somebody who was 96 and all of her friends and family are gone except a very small group of us. And it's their money to spend, but it may not have been what she wanted. So, doing something even basic ahead of time, a cremation policy, or having, I want to be buried and this is where, and I've purchased something. It's not even about the cost so much as the effort that has to go into dealing with remains. And Beth said there are some really great things you can do these days, right? I've had people who want their cremains made into coral and placed in the ocean. They want to be shot into space, right? There's all kinds of things you want to do. But one of the more serious things I talk to people about is um, if things are important to you that may not be important to your family, put them down, right? I have clients who have different levels of religious observance within their faith. And so maybe the parents want something more religious or less religious than their sons or daughters are. Clients who are I've had clients who are Jehovah's Witnesses who feel very particular about pieces at death that maybe their children are not. So being detailed, and I'm going to also say having that person who's responsible. That's the last bullet point on this slide right here. You've got 6 kids. Well, if you don't name one person to handle things, and all 6 of them are going to have to sign off on things. They don't just let one person just take your body and do whatever. So making it easier by having someone who is that designee, and then a successor designee, right? Making sure we have sort of again, I would say a deep bench, my baseball analogy, a deep bench so that we've got lots of people who can pick from, but we have one person in charge. And maybe that person's the one who's got a cool head. Maybe that person is someone who deals with hard things under pressure. Or maybe that person has the same level of observance that you do within your faith tradition. So, again, finding that person who you feel comfortable will make the choices that you want to have made or will effectuate your choices is really important. And this is a real tough one for families. So, we emphasize this a lot when we meet, not because we're expecting you and your imminent demise, but we know that, again, that we all die. So making it as easy as we can on the people who are going to be doing this work. So, and in fact, one of the comments, again, thinking about it being kind of creepy or grim, that does feel hard. That is a little bit like what to do with my body, right? That does feel kind of creepy and grim, but it will feel much easier when you're the ones having to make decisions for someone, or you might rest easier knowing that your decision makers know what you want.
Yeah, it is difficult, and that's why it is important, if you at all can, to tell your family who's in charge. And I will have different clients, and some people will spread these responsibilities around. You're in charge of the services, but then you're in charge of my medical decisions, and you're in charge of financials. And if that works in your family, then great. Or sometimes people just be like, you know what, this is the person who's going to be in charge of everything. But then let everyone know, because I think one of the saddest things that I see is after a family has had services for the loss of a loved one, and the personal representative or trustee comes into my office, and I say, how were services? And they say, it was horrible. Everybody was fighting, just that's just heartbreaking. That's not what we want. We want everybody to get along and to be able to celebrate a life, right? Remember the good things. And all of the conversations, as awkward as they might be, go toward making that happen. And so, again, when somebody has passed away, we get a lot of times the call right away. And the first thing we'll say is, okay, do you know where the documents are? Did they leave you a list of assets? That's what it's all about. Because at the same time that they're trying to locate that, everybody is grieving. And people don't think clearly when they're grieving. My dad passed away about 2 years ago, and it took me, and I do this for a living. It took me about a year to fill in a particular form to transfer some of his assets. I just didn't have the emotional ability to fill in the form, and it was an easy form. And so, as people are grieving, the more assistance that you can give them, the better.
I have to apologize. My dog is being a little rowdy this morning, so I'm trying to control Ricky over here a little bit as we as we talk. So if I keep sort of leaning down or muting, it's just because I'm trying to get my old dog to relax a little bit. He wants to go out and then promptly wants to come back 3 seconds later. So it's not you, it's me. Sorry about that.
That's so funny. But you know what? Maybe we should talk about that. And I didn't even put in a slide about that. But that is also an important thing, because who would take care of your pets if something happens to you, right? This is a good conversation to have with people as well, so that they know, first of all, if something happens to you, somebody's got to feed the dog, right? But then ultimately, who takes them too, right?
Right. And you'll note when we meet with you guys, we bring this up, right? If you have pets, some people have devices with money because, of course, pets are expensive, right? Food, vet, supplies, kenneling. I mean, none of it is inexpensive. They don't grow up and leave. And so for clients, I just talked to this lovely couple, and they have 5 dogs, I believe, and 3 are from a particular rescue group where they have to go back to that rescue group and they have the right of to take those dogs back. And the other one has health issues. And yeah, having a little discussion about who's going to take Fido is not a terrible idea, and planning for it's an even better one.
So the kind of the theme for all of this, right, is I would say you talk to your family, have an open discussion, an honest discussion. Do you have to lay your soul bare? No, you do not. But who's going to be in charge and where your documents are is, I think, easily the most important thing to cover. And that it sets expectations for everybody as to what's supposed to happen in that time of crisis.
And for clients who have complicated situations or they want to involve us in the process, we can do that. Right? There've been many clients who want to sit down and have a meeting where their kid that is in charge, we're meeting together to talk through the documents. How do they work? What are they going to do? When do they use it? Because they feel like maybe they don't have the bandwidth or the information that they really want to convey in this how to talk to your loved ones, right? They're not sure how to do that because they just don't know exactly what's the important stuff to tell them. So we've each had a lot of meetings over the years, and we call them sort of a family conference, right? And that's in addition to your estate plan. It's not something that's part of what you've already paid us for. But for some people, it's worth it to have that kind of meeting because it's worth it to have their clients also get to know us. And for our older clients who feel like this is going to happen sooner rather than later to them, they believe that this is the beginning of a relationship where we end up advising them, right? So best advice is sometimes being able to know that that the handoff has happened, or there's going to be a handoff, and they know how that will work, and that their person that they've named feels better because they now are not completely shocked by like, what do I do with this document? I don't know. It's just a bunch of papers. Like, I'm not really sure what this says or how this works. And they know that they can ask for help. That's one of the more important pieces too, is that you tell your people, it doesn't have to be us, right? But they can seek advice, not the teller at the bank, by the way, not the assistant to your financial advisor who told my client they have 3 days after death to pull out someone's account. That's called theft.
Yikes.
So I mean, real advice. They can always do that. And that is an expense that's payable by you or by your estate should they need to seek it. And we tell people it's better to ask for advice before you act than to act and then pay us to fix it. And much less expensive too.
And I think that a lot of people have the urge to try to let their loved ones know, like, this is every single step of what you need to do. And maybe for some families that works. But my experience is that for most people who have lost a loved one, that they come into my office and they basically say, here, these are the papers that I have and all the information, and they don't know what to do. And we don't expect them to know what to do. All that they really need to know is it's okay to ask for help, and we're here to help if they want help or if they don't like us, and that's okay. Not everybody likes everybody. Then we will be more than happy to refer them to another attorney if they can find another attorney, but they should ask for help because people don't know what they don't know, and this isn't something that you know how to do unless you've done it before, and even then sometimes people don't know what to do. One other thing I will point out is that a lot of times people think that if they have a will, that it will avoid probate, and that is not true. Now, does that mean your family needs to know how to manage a probate? Of course not. But in the state of Colorado, if on a person's date of death you have more than $86,000, and that number is from last year, they haven't released the number for this year yet. I would expect it would be like $88,000 or something like that, or any real property in a person's name, then it will trigger a probate. Probate is not the end of the world. It is just a process, and they can do a probate on their own, or they can hire an attorney to help them. But the will is not really what dictates whether or not there will be a probate, to transfer the assets upon death. Purpose of probate is really just to transfer the title of assets from the deceased person to the new owner. And that's a court process that's done while the family and the loved ones are settling creditor claims and resolving disputes. And so it is a process that takes a minimum of 6 months. Um, Average attorney's fees, I would say, are usually someplace between $5,000 to $8,000 or $9,000, depending upon how complex the estate is. But this is also why when we tell people to come in with their list of assets, that it is so important that they have not only the list of assets, but also how are things titled and are there beneficiaries on the assets? Because there are some assets that really the will doesn't control. And those would be things that name beneficiaries on the accounts. On your IRA, your life insurance, your 401k, you fill in the beneficiary designation form with the company that holds that assets, and that takes precedence over your will. And the same thing if you own things in joint tenancy. So it's not enough even just to have the list of assets, but to know who's named as the beneficiary on all those accounts or how they're titled. That's really what it's all about. So that list of assets, the more complete you can make it, the better. Um, Now, that's if we have to deal with a probate. We have a lot of clients who also have trust. And so, Josie, how do you deal with clients who have trust and where they start the process?
So they come in, when a loved one has died or it becomes incapacitated, the person they've named as successor trustee in their revocable trust, also called a living trust. I've also seen loving trust. Those are all what we're talking about here. They're now the successor trustee. So instead of a probate process where the court is, and a will is designed to go through probate. That's what a will is for. So like when we say it doesn't avoid probate, it is intended for probate. So the revocable trust is a private process, right? The trust administration doesn't involve the courts. There are no public filings. The successor trustee comes in and we have that person basically say, I agree to be the successor trustee. And then we work with them on the assets that are either titled in the trust or are directed to the trust. So, an example might be my client never retitled their checking and savings accounts into the name of their revocable trust, but they did put a pay on death designation that names the trust. So, talking through with the trustee about first, we get you in charge so that you can show third parties that I am now the trustee of this trust. We get a tax ID number, just like we would in a probate. This is because everything needs to come out of the decedent and the social security number and now go into the EIN or tax ID number, same thing for a trust or for an estate. But I talk to the trustee also about what their duties are. Because when we say trustee and we say things like agent under a power of attorney, or we say personal representative, it's a good thing to tell your family that this isn't you just being in charge and you get to care about you. You have a hat on called a fiduciary. And those are all different types of fiduciaries, meaning they owe duties. They owe duties to other people. The duty is to avoid self-dealing, the duty of fairness, the duty of honesty, the law. So both to creditors and to beneficiaries. So we talk through with that trustee what it is to accept this office, right? That you are now on the hook for certain things. You have responsibilities to yourself and to others. You have to do reporting to them because you want that trustee to tell everyone what's in this trust. You want them to tell them where the money went and what money came in. That's what we call an accounting. So we talk through with your trustee, what is it to put that hat on? Not the beneficiary hat, but the trustee hat, the fiduciary hat. Um, and then walk them through the stages of notification to people, collecting of assets, dealing with creditors, dealing with expenses in the estate, and then hopefully ultimately how to get it distributed. And what Beth is talking about with 6 months for a probate being a minimum, that's what the court requires you to keep it open for a minimum of time, but it often takes a lot longer than that. Now, trust administrations can too, right? It is sometimes hard, as Beth talked about, to fill out a form because you're just trying to survive the grief that you're managing, right? So sometimes these things take longer, but that's part of what we are here for. I tell clients we can't help you with the grief, we can help you with the paperwork, right? We can't make things easier in terms of how your emotional plays, but we can make it easier when it comes to getting things done.
Exactly. And I will say we don't expect anybody to know how to do this. I don't expect somebody to walk into my office and say, I know how to be a personal representative or a trustee. And in fact, the number of times that that has happened, I can probably, count on one hand, right? People walk in, they say, I know I'm the trustee. I'm not sure what to do. We expect that. We don't expect them to know what to do. We expect them to ask for help.
Oh, and I want to emphasize that actually, that I think sometimes people feel disappointed in themselves that they need to seek advice. But I don't know how to fix my car, right? I don't know how to deal with the plumbing. I don't know how to deal with my sprinklers. Like I bring in people who know what they're doing. And so as a homeowner, I don't know all of the things I should know about taking care of my house, but I have people to advise me on that. So that's our job, is to help them understand what they will do, how they will do it, and the obligations that they owe other people while they're in the process.
And so, of course, we are here to help. And if it is something other than what we do, whether it's tax related, needing financial advisors, even sometimes dentists, whatever it is, we do know lots of people around town. So we're always happy to give referrals to your loved ones for anything that they might need. And we're here to help in those times where there is someone who is either sick or has passed away. We are here as a resource for you and for the people that you've named and entrusted to help you. Now, of course, because we're attorneys, we went over, and I apologize. You all stuck with us though, a full extra 12 minutes. So I want to thank you for that. And we'll stick around here for a couple more minutes and do any questions. But I just want to say, again, and we can't say it enough, we've said it a ton of times. This is all about just opening up those doors of communication and talking to your family in whatever way you feel comfortable. And whatever information you give, it's a good thing because it helps them.
And thank you guys for making the time to come and to listen to us talk about this. This is obviously something we're very passionate about, and care deeply about, not just professionally, but personally. And so I love the fact that so many of our clients and their loved ones would be interested in hearing us talk about this because it's important. So thank you.
Yeah, yeah. Thanks to everybody. And let's see here. I see some people are leaving, and that is just fine. I'm going to scroll through some questions I see in the chat.
Yeah, should you share your
Um,
wealth with your adult children? I'm guessing share information about your wealth. And Boulder, Colorado, earlier you had posted about people get a little nervous that they're worth more to their children dead than alive. If you are worried your children will kill you, that's a whole nother ball of worms or wax that we can't help you with today. But I hear what you're also saying. I do. But I do think it's important. Now, again, I don't know that the level of like this is all we have and this is the dollar amount is important. I am at least a fan of things like we have an IRA with Schwab. And the account number ends with 1234, right? I have a life insurance policy with John Hancock, and the policy is ends in 4321. You don't have to say the values of them if that doesn't
right.
make you comfortable. I think it's but also again making sure that you've talked to your people about, do I have enough money for my care? If I need to be in long-term care, do I have long-term care insurance? What these are my values as it comes to what's going to be spent on my care. That kind of frank discussion, or we don't have enough for that kind of care, and maybe that's a discussion to have with your people. But I don't think you have to be as detailed, right? You don't have to say the dollar amounts. You can simply be telling them the location of those assets. That's going to be, again, like you're already 90% there. The number that goes with them is going to change over time. You have an IRA and you're living off it. Well, that's going to be a lot smaller when you die than it is today. So I don't know that I focus so much on the amounts. And Beth, you can speak to this too, but I just focus on knowing that they exist.
Yep, I completely agree. And I think it's actually in some situations helpful not to tell the amounts because sometimes otherwise people get attached to the amount that they might be inheriting, right? My estate is worth $5 million. And so that means if my parents have two children, I'm getting 2.5 million. Well, but then, mom and dad need care and that amount goes down and it's mom and dad's money. And that is my firm belief, first and foremost is the children only inherit whatever is left. Inheritance is not a right. It is a benefit. And so I think it's not about the amount as much as where the assets are.
Karen, you asked a question about I am trustee of my own trust. Do I need to assign a successor trustee along with the powers of attorney individual? So, probably when you executed your revocable trust, you have a successor trustee named in there, if not even maybe a second successor. So, you'd want to go back and look at your document, or if you did your documents with us, then maybe the summary that we had sent to you before you signed your documents, right? That might have just so it's faster to look through that sometimes if that's accurate. But your power of attorney is going to be a separate document because if I'm incapacitated, my successor trustee of my revocable trust is going to manage those assets. But I have to file tax returns. I need to deal with creditors. I have to deal with the lawsuit I'm in. That's going to be under my financial power of attorney. Sometimes you've named the same people, sometimes they're going to be different, but both documents have language about coordinating together so that they work with one another to take care of whatever has come up. So I would encourage all of you who say, and I get this a lot, I don't remember who I named as my successor. Well, take a look. This is an opportunity to pull that notebook off the shelf, blow off all that dust, open it back up again from years ago and to take a look and see what you have because maybe it's not reflective of your wishes anymore. And so again, that this would be an opportunity to bring it up to date with what you want.
And for those of you that we did your documents, it's Article 3, Section 4, was where you name the trustee. And I will disagree with Josie on one thing. My clients review their documents regularly, so there's no dust on the binders. They are looking at them at least weekly, and so I know that they are up to date on exactly who they've named.
Your clients are better than mine, Beth. So that's all I
I
can
know
say.
they do. They look at them all the time, daily even. So no, we don't expect people to look at their documents regularly. We expect there to be dust. That's why you do reviews.
Yeah.
And somebody asked if this presentation will be available. This is being recorded. It will be available on our website so that you can share it with your loved ones. And hopefully that can also open up conversation with them.
So
Thank
one of the
you.
questions we have here is about benefit of having a trust versus a living will. Completely different documents that will do different things. The living will, again, is dealing with being on a ventilator and having a terminal condition or a persistent vegetative state. Now, the benefit of having the revocable trust is that when you're in that condition, your successor trustee can step in and be managing your trust assets and dealing with your trust while you're alive. A will only speaks when you die. A revocable or living trust is in existence both during our lifetimes, when we are capable, when we are incapacitated, and then at our death. So they don't really work together, except that needing a living will is going to trigger that successor trustee needing to step up in your revocable trust. And thank you guys. Thank you for your good questions. Thank you for participating. And then again, reach out to us if we can be of service to you. But we just are really grateful that you'd spend a little Saturday morning with us.